very happy to be with you. I want to approach the topic today from, and I hope that I will have time to do so, from three perspectives. The last of which is a Quranic perspective, but um, I'll let the first two speak for themselves. Um, and I want to profess uh, um, this conversation by saying that I speak as an insider to the legal system, as someone I don't stand at a distance from uh, from this legal system, but I am consider myself an active participant who has a real interest in how this legal system uh, constructs itself and manifests itself in our modern world. Um, Although this is for a different time perhaps and a different conversation, um, in the same way that I recall reading that uh, a non-Jew cannot truly understand Talmudic law, that only a Jew can understand Talmudic law. Uh, I believe that about legal systems. An outsider to a legal system cannot truly understand the legal system. Uh, and the for reasons perhaps that will become obvious in the presentation itself. Okay, well, let me start out by my first approach, let's say, that um, every legal culture um, has its fundamental world of words. Um, this is because legal reasoning is not about beliefs or theories implemented, nor is law about sovereign commands that are mechanically made real. Law is a practice, and it is a practice of arguments and language, words, that are learned, made, developed, accepted, rejected, reconstituted, reasserted. Law is the realm of what I have called early on in my career a linguistic practice. And this linguistic practice reflects modes of thinking, and thinking about normativities, if you will, thinking about the do's and don'ts, and with the full realization that quite often when law ultimately has to use violence, in other words, use ultimate coercion, in many ways law has already failed. It is in the normativities, the modes of thinking, and the effectiveness of the linguistic practice that law most compellingly manifests itself. Now, a useful way, I think, to understand what at least those engaged in the dynamics of law think they are doing, at the most basic level, is they think that they are searching for order. Um, uh, of course, the search for order is an old, very old human endeavor. Um, from it, it is manifested in the most primitive cave paintings. It is manifested in the invention of counting and mathematics, in the attempt to wrestle with history and document history in some form. So it is a deeply rooted in human consciousness, um, a deeply rooted human need, if we might say, and it, its search for order. Um, it, it is it cannot be separated from the epistemological endeavor that it entails. Um, Now, that's at the most basic level, but even religious ritual itself and the emergence, the from the earliest times, when as human beings attempt to adopt, religious rituals as an as a social activity. Again, it is reflects this fact, the search for order. However, what we notice about the is well, I'll say the Islamic legal system, but we also see it as a feature um, of all legal systems before the modern world, and especially religious legal systems like the Islamic legal system, is the, and the search for order evolves into the notion of obligation, and obligation as the center of the relationship with God and also with community. Obligation comes to be the closest thing to um, a, describing what a truly virtuous person in a Muslim community, and indeed what a virtuous Muslim community is, and in what Iman is, what taqwa is, Iman, faithfulness, piety, or taqwa, again, let's just use piety for as a stronger sense of piety, being God conscious, being God aware in everything. Now, obligation, in a word, acts out the notion of solidarity with God and solidarity with fellow Muslims. It is can be described as sort of the mythic center of law, the reinforcements of bonds of solidarity with God and bonds of solidarity with the community. Now, here I think the idea of Tawheed and the idea of believing in one God is rather um, important to understanding the notion of obligation within the systematic telos of Islamic law. Tawheed, the belief in one God, means a belief in right and wrong, in a good and bad, in a ma'ruf and munkar. And going a step further, that the telos of obligation in Islamic law differentiates between the world of principle and hawa, or vanity, or vanity is I guess the translation for hawa. The difference between haqq and a world in which one commits to a godly, righteous, livelihood or living, and the opposite, which is always contrasted as a form of hawa or vanity in the world. Now, obligation as solidarity between a human being and God, and obligations as the center of solidarity within the community itself, significantly, just at the outset, it contrasts with our modern notion of rights that protect us against the violence of the modern state and the centralized state. Significantly, the modern state cannot achieve solidarity with God or solidarity within the community through its normal mechanisms, and that is the ability to coerce and the ability to commit violence. In many ways, centralized power is about violence, the ability to deliver violence. It does not affirm solidarity with God or community, and indeed it often acts to undermine this solidarity, because coercion, which is the mechanisms of law, is compulsion, not obligation, but compulsion. Obligation as solidarity is quintessentially about consent, about a deeper understanding of law beyond the element of state coercive powers. Now, I've overlooked, because of what's going on in Gaza, I'm a bit sleep deprived, but so forgive me for if I overlook certain things and have to go back to them. But what we in thinking about the notion of obligation and solidarity, it helps to remember that Sharia itself is quintessentially, or it's sui generis, is about a way to behave or a way to go about life. That is why Sharia discourses can cover a broad array of things that might fall under what we normally think of as law in a positivistic sense, or might cover topics that have little to do with law in a positivistic sense. If you think about it, Sharia can talk about the obligation to love God, or the obligation to have taqwa, or the obligation, that things that are normally not thought of in our modern setting as within the purview of legal norms. And at the same time, it can talk about things like the obligation not to kill, something that we are very comfortable thinking of as that might be enforceable by law. But as Sharia, in its core, as a ongoing narrative, an ongoing categorization, reordering of a way to go about life, and a way to build solidarity with the Almighty, with the one God who represents truth and represents goodness, as opposed to, and as I said, represents ultimate truth as opposed to vanity, and ultimate goodness as opposed to everything that is opposite of goodness. The irony in this, though, or the paradox and the tension, is that although Sharia is obligation, and Sharia is quintessentially the relationship to the divine and the relationship to Muslim community, it is fair to say that Sharia is about being a Muslim, what defines a Muslim, the identity, if you will, the narrative of what constitutes a Muslim. In the world of ordering, it is a systematic attempt to order, to categorize, to imagine, to think of what the Muslimness is about. Now, at the same time, as I'm sure anyone who has dealt with the Sharia tradition knows, Sharia is discursive and dialectical. Sharia is not a set of codified rules, but is far closer to a set of principles to be weighed and evaluated, considered and studied in their various nuances, not simply a code of law. We all know that there are many schools of thought, some extinct, some alive, and that all schools of thought are equally legitimate, an equal representation of the way of God, the path of God, of the Sharia of God. But we also know that within each school, on practically any legal matter, you have numerous defunct opinions, opinions that are claimed to be living, non-defunct opinions, and importantly, numerous claims that consensus has settled points of law, and also at the same time a realization that all these claims of consensus, for the most part, are mythic. They play a ordering role, but they are not to be taken as in any way empirically to be the truth. And so, although matters are constantly claimed to be have been resolved through consensus, we also know that if you study the law long and hard, you will also see that matters are always reopened and always reinvestigated. Now, so, and if you, there is a story that I learned from, I learned orally from the old days, the days of dealing with the sages of Sharia, and since we have experts on Jewish law present in this conference, I think it might intrigue them as well. This is a story about a sheikh and his student. The student tells the sheikh, I have been studying with you for many years now, and I am ready to at least have my own halaqah, my own amud. Amud is literally translates into a corner in the mosque, so that you can teach your own class. In other words, he's saying that I'm now prepared to be my own professor, right? And so the student tells the sheikh that, I am now ready to have my own amud and my own circle of learning, my own halaqah, because I have been studying with you for many years. And the sheikh says to the student, you're not ready. The student argues with the sheikh. So the sheikh says, "Okay, well, I'll let me ask you a question and see how you'll handle this." And he tells them that there are two people that they go to kill a man, and they come out committing the foul deed. One is stained with blood and the other is not. Which one of them needs to wash? And the student says, well, clearly, we know who needs to wash. The one stained was the stain. And the sheikh says, no, that's wrong. Actually what's going to happen is that the one who is not stained is going to look at his friend and see that his friend has blood on it, blood on him, and the one who has blood on him is going to look at his friend and see that he doesn't have a blood on him. So actually the person who's going to wash is the person who is not stained with blood. So the student apologizes and says, okay, I'm sorry, I didn't think of that. Ask me the question again. So, to get, in the interest of time, although the teacher tells the student the story several times, and every time the student tries to answer it by basically repeating what the teacher told them, uh, every time it's wrong. One time it's wrong because it's actually the person who's clean is going to look at the stained person and then think that he's dirty, and that the person who's dirty is going to look at the clean person and think, well, I'm clean, and so they're going to mislead. Another time it's going to be because um, uh, there is some type of external element, like they're going to walk and then someone is going to uh, 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 they're going to go to a river, and then they're going to look in the river, and one person is going to realize that they have the stain. But they get, after this, going through this exercise, and every time the student is getting the answer wrong, finally they've gone through all the possible scenarios, and again the teacher says, well, okay, one last time, I'll ask you this scenario one last time. So two people go to kill a person, one person immersed stained, the other person doesn't. Who needs to wash? And the student again regurgitates what the teacher had just told him at last. Then the teacher says, all along you have uh, answered, but but the real answer was that the wrong question is being asked. The Why were they killing the person? In light of the fact that they went to murder someone, it is hardly the question that they need to wash. That's why you're not ready. That stayed with me because that is exactly how it reminds me quite a bit of what we do with our first year law students. And it reminds me of the mechanisms of law, the language of law, and the sense where you cultivate an awareness of what the issue is rather than what the right answer is. Anyway, I just thought I'd share this because I'm sure my Jewish colleagues would appreciate the scenario. Anyway, so now law, Sharia, as a way, as a path, and I have to watch the time since I want to get to my three approaches, as a path, and as a path of obligations rather than rights. Now here I want to say something that when it came to the state, Muslim jurists, Muslim scholars, had fantasized a vision of the state as occupied by something akin, maybe not quite like Farabi's philosopher king, but as we know, a mujtahid who is effectively like a philosopher king, who affirms the obligations of solidarity with God and community. But I believe that they upheld this ideal as an apotheosis and an unachievable and unreal ideal. That in the absence of the Khalifa, that all-knowing mujtahid, the unachievable, unrealizable, all-knowing mujtahid, Sharia became the Khalifa, and the state was relevant in terms of the hard and fast rules it applied to society, but it was not relevant in terms of the constitution of what counted as the path to God. In other words, centralized power was, centralized power as a centrifugal force became important for protection in the here and now, but unimportant, the realistic, non-ideal, non-philosophical-like state became not as important in the ideology of obligation as a counter to the centrifugal forces of the state. Put differently, we know that one of the most frustrating things about the Sharia text and Sharia traditions is how little they tell us about the law of the state in their time. We have to work hard and research very hard to even get a glimpse of the actual law applied by the state in any one time, in any one place. We get glimpses of it in Ahkam al-Qada, but even in Ahkam al-Qada, or the rules of the judiciary, it often, what juristic scholars choose to preserve is often very selective. They will preserve the opinions of the most prominent jurists, Al-Izz bin Abd al-Salam, maybe claims of Qada Abu Yusuf, or if we have an unusual text like Akhbar al-Qada by Waqi'a or something like that. But there is a clear bias against preserving and incorporating and integrating the law of the state into Sharia sources. So Sharia sources preserve, if you will, their purity as discourses about obligation towards God and obligation towards community. And the law of the state is treated consistently as an other. Now note, immediately, this poses a serious tension in our modern age. An all-encompassing state, a state with an unrelenting centrifugal force, a state that is, if the centrifugal force of the state is all dominant, and in fact centers the laws in itself, including the laws of Sharia. As I said, the state is ill-equipped to in any way engage the very idea of obligation. the state can engage the idea of compulsion, but not obligation. Obligation is an entirely different animal, especially if it is to center solidarity with God and solidarity with the ummah, or with the community. Citing the example of the Prophet doesn't help us, because the authority of the Prophet was akin to what I described as the apotheosis of the Mujtahid king or the Mujtahid ruler, the so-called Khalifa. I do not believe that Muslim jurists ultimately compromised with the reality. I believe that Muslim jurists did what jurists do best, and that is they constructed illegal fiction that they knew is indeed illegal fiction, that from the very beginning they set the bar so high in the construction of the tradition of the companions of the Prophet as the Khulafa al-Rashidin in Sunni Islam, as the rightly guided Khalifas, in order to interrogate and in order to, through narrative, through the power of narrative, to interrogate and shame and embarrass what they knew was something far less, because the ideal was never actually taken seriously. And that is why, from the very beginning, it is Sharia that was made the true Khalifa, the true embodiment of Muslim identity and the mores of Muslim society. In the second approach, and I don't know, I might not get to my third, the Quranic one, which is a shame, but, you know, we can't have everything in life. I build on the jurisprudence of a quite significant American legal philosopher, Robert Cover. And Robert Cover's perhaps approach was, well, a lot of people sort of borrowed his approach without giving him credit. So the expression juris generic, or the juris generic model of law, some of you might have heard of that. Well, that originates with Robert Cover, and, you know, give credit where it's due. And the most important significant contribution of Robert Cover, and one that I want to co-opt here and talk about, is Robert Cover alerted us to how simplistic and largely false the idea of law as the exclusive monopoly of the state. Indeed, any individual lives under the authority of concentric, overlapping systems of laws. There is the law of the family you live in, the law perhaps of the neighborhood you live in, the laws of what you know the police enforce or not enforce in your neighborhood, the law perhaps of the church that you belong to or the synagogue, the law of the school that you might teach in, then the law of the courts. There is the law written in the books, and there is a law, as any practicing lawyer will tell you, as you know, the eccentricities and proclivities of particular judges when you appear in their court. Some judges, you do certain things in their courts, and other judges, you just don't do these things. You often know how a judge will behave, and you also know that quite often what a judge or how a judge behaves has a relation to law in the text, in the books, but not necessarily so. It is not necessarily an intimate relationship. So there are, in other words, what Robert Cover points out as a various norms of law that are always active in society. The law of the state is only one of them. And in fact, the nomos, or what Robert Cover sometimes referred to as the legal DNA, the beginnings of legal norms, originate in what he called nomic communities. And these nomic communities are influencing the law of the state in a variety of ways by the production of narrative and meaning. Now, one of the most important things that I think Muslim jurists understood very well when they excluded the law of the state from their sources on Sharia, of course, long before Robert Cover, but that when the state actually settles on a meaning obtained from the various nomic communities that it rules over, the state commits an act of epistemological, if you will, compulsion or violence. It clamps down, and from the world of meanings out there, from the many interpretive possibilities out there, the state picks a particular meaning, a particular interpretation, a particular narrative, and now enforces it through the instrument of coercion. So the state, if you will, is not, and from that perspective, does not generate legal possibilities or law possibilities, but the state is actually a killer of law. It takes one opinion from the realm of opinions and says, this is it. But it is also a losing battle, because the minute that the state uses coercion to attempt to create solidarity with God and solidarity with the community, the seeds for dissension and breaking away are immediately planted. Because, as I said, the state is a centrifugal force, a centralizing force, while the world of nomos is a constantly rich and meaning-producing force that responds to overlapping communities of belonging and meaning that define the human being. So let me reach a tentative conclusion just in case, because I have 10 minutes. I run out of time and I don't get fully to my Quranic approach. The modern state, in terms of Sharia, One, I think, of the truly deprecating developments and impoverishing developments. And we can have a conversation about the why. I think a great deal has to do with colonialism and with the politics of defeat and the politics of brutalization and the politics of subordination. When people are subordinated, when people are brutalized, they try to order meaning in their life in increasingly narrow and constrained and often uncreative and unimaginative ways. They try to clamp down on the sense of anarchy and chaos by imagining that they can go to a savior. And in the modern Muslim psyche, the savior has always been imagined since the post-colonial age to be the state. The state as a centralizing force that can protect Sharia from the imagined or real transgressions and deconstructions that has fallen Sharia in the modern age. But the Muslim modern consciousness did not realize what I think medieval jurists realized, that the state as a savior, the state as a khalifa, the state as a philosopher king, the state as a mujtahid mutlaq in Islamic terms, the state as all-knowing is but a legal fiction. That in fact, the state is incapable of standing in for the haqq, that is God, and the state is incapable of overcoming the vagaries of whim that the pious Muslim jurists imagined Sharia to be consistently involved and wrestling with. The state, in fact, as we said, the state will always abuse the logic of obligation. And that is precisely why in the modern age we talk about rights to try to balance the abuses and the excesses and the coercive powers of the state. Let me take the last 10 minutes to get to the Quranic perspective, because I think it fits in rather seamlessly and naturally. Sharia, for centuries, it's clear from my presentation, the way that Sharia is constructed as this discursive, often dialectical narrative about the perfection and ultimate majesty of God, the center of all goodness and the center of all truth, was always kept at a distance from the state, as clearly evident from the texts that memorialized and preserved Sharia. In these texts, the state is quite purposefully, quite intentionally absent. We know the regulations of the state, perhaps from the texts of Insha, like Subh al-Asha, Qalqashandi's book, which gives us, or something like the Geniza documents, which gives us little snippets of what the state was and is and so on. But the texts of Sharia, even the Fatawa literature, will leave out of the realm of God's living law what the state decided or the state did. Now, I believe, and I would argue, that in the modern age, not only does the relationship to the state, as I said, the state needs rights in order to protect the individual and the community from the, even under its best versions, the oppressive powers of the state, the coercive, and as Robert Covert would put it, the nomos killing powers of the state. But when we go to the Quran, let me share with you just a passage, as if we are back in seminary. And let me first share the passage, and this is just one. It's a bit long, but I think necessary. I could have picked the passage from Surah Al-Isra, or the chapter called Al-Isra, or from Tawbah, or from Surah Al-Furqan, but I think one is fairly representative. Okay. And I will dispense with reading the Arabic, although the Arabic has its own magic, in the interests of time. Okay. وَقَضَى رَبُّكَ, your God has ruled. وَقَضَى رَبُّكَ أَلَّا تَعْبُدُوا إِلَّا إِيَّاهُ, God has ruled that you worship no God, no deity, side by side with God. For God has ordained that you worship none other but God, and to do good unto thy parents, should one of them or both attain to an old age in your care. Never say uff to them. Uff is a expression of impatience or scolding them. Never say uff to them or scold them, but always speak unto them reverently and kindly, and spread over them humbly the wings of your tenderness, of thy tenderness, and say, O my sustainer, bestow thy grace upon them, even as they cherished and reared me when I was a child. Your sustainer is fully aware of what is in your hearts. If you are righteous, God will forgive you your errors, for behold, God is most forgiving to those who turn unto God again and again. And give his due, and give your due to the near of kin, as well as to the needy and the wayfarer, but do not squander thy substance senselessly. Behold, squanderers are indeed of the ilk of Satan's, inasmuch as Satan has indeed proved most ungrateful to his sustainer. And if thou must turn aside from those that are in want, because thou thyself art seeking to obtain thy sustainer's grace and hoping for it, at least speak kindly and gently to them. And neither allow thy hand to remain shackled to thy neck. In other words, don't be stingy. That's an idiom. Don't be stingy. And stretch it, nor stretch its force to utmost limit of thy capacity, lest thou find thyself blamed by thy dependents, or even destitute. Behold, thy sustainers grants abundant sustenance, or give it in scant measure unto whomever God wills. Verily, fully aware is God of the needs of God's creatures, and sees them all. Hence, do not kill your children for fear or poverty. It is we, i.e. God, who shall provide sustenance for them. Verily, killing them is a great sin. And do not commit adultery, for behold, it is an abomination and an evil way. And do not take any human being's life, the life which God has willed to be sacred, other than in the pursuit of justice. Hence, if anyone has been slain wrongfully, we have empowered the defender of such person's rights to exact a just retribution. But even so, let him, i.e. the person exacting retribution, not exceed the bounds of equity in retributive killing. And as for him who has been slain wrongfully, behold, he is indeed scored by God. And do not touch the substance of an orphan. In other words, don't steal the orphan's money, save to improve it before the orphan comes to an age. In other words, don't deal with the wealth of an orphan unless you're going to increase it, not take away from it. And be true to every promise, for verily on the day of judgment you will be called to account for every promise which you have made. And give full measure whenever you measure, and weigh with a balance that is true. This will be for your good and best in the end. The Quran has a number of passages that lay out what read the equivalent or the closest thing that comes in other traditions are the 10 Commandments of Moses, if you will. These core setting out of obligations, as the Quran describes it, the life of the Rabbaniyun, the life of the godly. The modern Muslim mind has, for again reasons we can go into if you wish, has tended to think that the fulfillment of Islamic law is in the fulfillment of rules. But no rule is there without a purpose in solidarity through obligation. Solidarity either with God or solidarity with community. It is not through rules that the essence of law, I would argue, is achieved. It is through principles. And what the Quran sets out in these commandments are indeed principles, normative possibilities to be investigated, pursued, and every attempt at fulfillment is presumptively a failure. In conclusion, I will close with this. I am not arguing for a typical, or whatever phrase you want to use, a secular state, but a reinvestigation in the meaning of, you want to call it a secular state, a religious state, a state that understands that religious obligation, the existence of solidarity with God and solidarity with community, the existence of fulfillment through the production of legal nomos cannot be through the instrumentality of the state. And thank you. I am 3 minutes over. Yeah, you know, yes. Um, but it, remember that, and there is so much of the Sufi and Sufi-esque tradition uh, talks about um, the most basic level is the level of Sharia. The level next to that is Haqiqah, and the level after Haqiqah, or so Sharia is only the first level of your engagement with God. The second level is where you attain, uh, you see the truth beyond the law, and that's haqiqah. And then the level beyond that is arfan, which is a level of sohbah, a level of a khalilullah, a level of not a partner with God, of course, on an equal term, but actually the truth that you realize is that there is no reality but God, um, and that whatever is uh, whatever is real about you, it is really God, and nothing beyond that. Now, of course, uh, the idea of obligation and solidarity with God, it is a the if all of us were perfect, um, perfect mu'minun, if all of us were perfect believers, uh, and all of us had the veil removed before our eyes, so that we see the truth of our existence from an Islamic perspective. uh, uh, God is the ultimate good, and God is the ultimate reality. God is the beginning without beginning, and God is the end without end. And in fact, we are, as you know, forgive me for the theological talk, but ultimately, when all said and done, the greatest honor and the greatest blessing is that we to accept your role as an instrumentality of God. Um, but that is neither achievable by any state, um, and if it is achievable at all, it is through willpower. The best that law can do is to not get in the way of the individual, or to assist the individual in that endeavor through exercises of obligation that strengthen the individual on that path. Um, I don't think it entails or implies in any way equality with God. Um, I don't think anyone remotely suggests that.